Welcome, everyone. I'm Una, the AI Innovation Lead here at Right Group, and I'm really pleased you could join us today. We're going to spend the next half hour unpacking a question that a lot of people are quietly wondering about right now. So when you use AI to create something, who actually owns it and how do you protect yourself? So I'm delighted to be joined by Sophie Everett-Develop from Mutatis Legal. Sophie specializes in intellectual property, AI, and digital law, and works with businesses around the world navigating exactly these questions. Before we get started, feel free to pop your questions into the Q&A feature at the bottom of the screen at any point, and we'll try to get through as many of those questions as we can at the end of today's session. Sophie, why does this matter? Reveal yourself. Delighted to have you here, Sophie. If someone is using AI to create content and not thinking about copyright at all, what is the real risk they are taking?
Laws were written for human creators, not for AI generated works. So for a business that uses AI without thinking about copyright, the risk is huge. And the risk for me has three sides. The first one is the ownership gap. So you may not own what you produce with AI. It will maybe fall under the public domain. So it means that you cannot stop a competitor copying your AI generated campaign or logo, or you cannot license it or sell it. So that's the first one. Second one is the infringement. So when you create something, an output with AI, it can reproduce maybe material like the AI model learned from. And it is the business that publishes the output that is exposed about that. So not the AI provider. And the third one is about the contracts. So if you promise a client, you own the content. For example, you are a graphic designer and you create a logo for your clients with AI. You cannot transfer the rights that you do not have. You could be in breach of your own contracts. So be careful.
Oh, wow. So a lot of risks, quite eye-opening, almost three substantial risks there you talked about. If people aren't thinking of copyright, then there's the ownership risk, the infringement, and then the contract itself. And I think that leads us nicely onto another big question that people are asking. So if I use AI to generate content, whether that be text, images, or code, is that actually protected by copyright, Sophie? Or am I assuming a level of ownership that might not exist?
So in most of the world, the answer is no. Copyright protects only a human author's own creative expression. So content essentially generated by AI is not protected by copyright, and that's really important. So the works should be the fruit of intellectual labor founded on creative choices of the author, or in Europe we say the author's own intellectual creation. In
Okay.
New Zealand, you have this Copyright Act. And if you check that, you have three conditions about copyright protection. The first one is the work must be original. There must be a human author. So the text defines the author as the person who creates the work. And also, the third one is the work must be recorded. So you cannot just have an idea. It has to be like in writing or otherwise, but recorded. And so pure AI output is not protected because the way to protect it is really to keep a real human in the loop. And if you see this Copyright Act also, it was written more than 30 years ago. And of course, it says nothing about generative AI. It doesn't really exist at the time. And so we need a human author if you want some protection. In New Zealand, and as in most countries, also copyright is so arising the moment the work is created or recorded. And the only exception is in the United States, where the registration of the copyright is required. So you have to go at the United States Copyright Office to register your copyright. And so we can see a lot of leading AI cases that came from the US because the Copyright Office must decide at each registration whether there was enough human authorship when they use AI. So that's really interesting.
It's super interesting, and almost we think the real issue is not just about whether something was created, but whether there is enough or sufficient human authorship for copyright to exist at all, which leads to the next question. If I use a tool like ChatGPT to write marketing copy or Midjourney perhaps to generate a logo, who legally owns that result? Is it me? Is it the platform? Or potentially no one?
So if you think about it, we can see maybe three candidates. In many countries, the answer will be potentially no one if you use AI like Midjourney, ChatGPT, whatever. So it's first, it's not the AI itself because no legal system recognize a machine, an AI, as an author. That's not possible at all. They don't have rights or obligations. It's no legal entity. So the
Mm-hmm.
authorship stays more, maybe we can say, with the person who creates the work. Maybe
Mm-hmm.
you as a user. Many of my clients think it's platform. Maybe for ChatGPT, it's like OpenAI, the company behind the platform because they say, oh, we can see in the terms and conditions, maybe they write something on that. But actually, in most of them, most of the terms and conditions of the platform, they actually say that the rights in the outputs belong to you, the user. But it's
Oh.
really important to know that terms can only go so far because a contract can allocate a right that exists. It cannot create one that does not. So they can say, oh, we give you the rights. But if there is no right, it's a problem. You don't know anything. So it's a misconception. And if the output carries no copyright in the first place, there is simply nothing for those terms to hand over. And that leaves you, maybe the user, and whether you own anything on how the work was made. So if you stay really poorly in the AI environment, for example, you do nothing but enter prompts, even if you put so many prompts like details or mini ones, the results, like the image, the text, the video, the music, the code, will not be protected by copyright at all. So it's really important, even whatever the terms of use say. I have one example. It's like a German court. It's really a recent
Okay.
case. German courts has just held that an AI generated logo gets no copyright because in that case the user just picked an output rather than really creating the logo itself. He just did some prompts and choose the output. And if it was from a paid subscription AI platform, because that was the argument of the person. So even if it's paid subscription AI platform, that doesn't mean that you own some copyright on your work.
This is interesting. And I imagine a lot of people that are listening, perhaps quite naively, like myself, always thought that by avoiding the free accounts or the free tools, that I had some kind of false security or lulled me into some type of false security or that I was protected. So that's interesting and quite a real example there in Germany about the paid accounts not protecting you as well. So yeah, just to be wary of that as well. So you've mentioned there, Sophie, as well, the importance of keeping a human in the loop as evidence of this authorship to almost protect us legally. So does that make a difference legally?
Sure. This is really the answer for this legal problem about copyright. So in virtually every country, the key test is the same. Whether there is a sufficient human creative work in the output, in the result. And if you are not staying in the AI environment only, because if you stay, as I've just mentioned, if you stay in the AI environment just doing prompts, it's not enough. If you go outside, maybe we can see some protection. For example, I told you in the United States Copyright Office, if you get some copyright or not, and
Hmm.
they were super clear that if it's 100% made by AI, it's not possible to have a copyright protection on the work. In Europe,
Oh,
the European Parliament said exactly the same thing. The US Copyright Office also refused, in a case, refused the protection for an award-winning image. So they want the award, but they don't get the protection, the copyright protection. And the guy did 624 prompts through Midjourney.
Wow.
So he changed a lot of things and he didn't get any protection. So now it's in appeal at the court, but that was the decision of the Copyright Office in the US. And also some European courts agreed that a prompt, so it's only an instruction, it's only an idea, and it's the AI that produces the form that you don't have really the control on that. If I write a prompt here and you write the same prompt at the same moment, we won't get the exact same results. We don't have enough human control on the
Yeah.
results.
Yeah.
And so will human authorship using AI does work in some cases. So we have seen some cases in the US Copyright Office. For example, one of the main one is they accepted a piece. We worked through dozens of cycles of manual editing. So the person did something with AI and then it did like by himself a lot of manual editing. So
Mhm.
selecting, arranging, editing outputs, even if it's from an AI material, if you can show that after that you worked really on that, just not minor changes, but like we work on that, it can work. For example, the author in that case recorded it with a video to prove it. So the more the human shapes the final form, the more of the work is protected. That is exactly the AI+Human process right group brand, so that's really good.
Yeah, that's the brand, and we've always championed the AI plus human. It can only ever work with the human in the driving seat first, deciding if AI is even needed and then at what level of control you're giving it. But it's nice to know that protects legally, and if you keep that human in the loop throughout, and the key is the substantive evidence of that human that we've just talked about. So I'm now imagining, and I'd say the audience are too, Sophie. So that video was a good idea to prove it that you mentioned before. Are there any other ways that people could document or show this human involvement if they ever needed to? What other tips do you have in addition to the video, etc.?
Like the goal is like keep a paper trail. Maybe you can
Okay.
save intermediate drafts. You can screenshots like a record of the manual edits and choices, the source files. So none is magic alone, but maybe together it is the evidence. If you go to court, if you have a problem, the court will wait to decide whether there were there was enough human input to be protected by copyright in case you have a problem or someone copying you.
Okay. So, like everything, it's evidence, and having evidence of anything,
Yeah.
especially in the legal world.
Jumping on that because
Yeah.
it's only in the US that you have to register, but
Okay.
like in all of the other countries, you don't really have a formal registration, like maybe a trademark or a patent. In copyright, we don't have that, it's automatic. So we don't have a proof by registering the copyright. So it's important that the author, the creator, will register by himself some recording.
Okay, excellent. And I'm now just imagining all these people deciding to start taking screenshots of their edits and their manual work after today as evidence, thinking creatively or prompting their AI to give them creative ways of keeping that paper trail as well. So, yeah, this kind of copyright protection and the uncertainty around it. Are there other ways then? So, you mentioned some of them there, like maybe trademarks and patents that people can use, and perhaps for even New Zealand businesses with international clients? Are there specific things for them to think about, like we know about GDPR or other overseas regulations, Sophie? What do you reckon?
So, for example, with contractors, if you have some contractors, it's important to put some maybe assignments and warranties in place in a contract. Same with the clients. Be precise maybe about what you can or cannot rather than permitting ownership you may not have. When where copyright is shaky, you create something totally with it. A good option is lean on rights that do not depend on it, do not depend on
Okay.
copyright. So you can use maybe other part of the right. For example, if you do an AI logo, you really love the logo, but it's done by AI, so you won't get any copyright protection. A good idea is just to register as a trademark. You can register as a trademark an AI logo. We don't care if it's AI generated for trademark. It's not a condition. It's a problem for copyright, but not for trademark. You can use also confidentiality, unfair competition. If someone is copying you in-house, you can do trade secret protection. So
Mhm.
you can really find other ways to do it. Do not go to court saying, I have a copyright on my AI generated logo. You will lose the case for sure.
Yeah.
So
Yeah.
please use other things if it's really AI generated, or the best is to keep the human in the loop.
Yeah.
Also, a big point, be careful because copyright is territorial. It's country
Yes.
based. So whether an AI assisted work is protected and who owns it, it's judged by the law of the country where the protection is claimed. In practice, usually where the copying or use infringement happens. If a competitor copies a Kiwi logo in Germany, it's German law decides whether there was any copyright to infringe. So it's really global. Also, if you have European clients, we have a lot of rules in Europe, that's for
Yep.
sure. The GDPR applies, so General Data Protection Regulation. So whenever personal data is processed, so if you include data, you paste that in AI tools, these are real in Europe, even if you are based in Australia, New Zealand, whatever. We have
Hmm.
also a new, because we love rules in Europe, we have this new AI Act that adds transparency. So now we need, from August 2nd, we will need to be transparent when we create AI content on European territory, and we need to label to say, oh, that image was AI generated, that video was AI generated, and so on. And we need to see that. So the message for New Zealand business with international clients is that content may be protected in New Zealand for copyright, for example, but maybe not abroad. It's not because it's protected in New Zealand that it is abroad. So it can be caught by privacy, AI rules far stricter than New Zealand's at the moment. And so be careful if you have a client offshore or if you sell products or services, especially in Europe, be careful with that.
Excellent, super insightful, Sophie, and some good guardrails that we often talk about from start to finish, which is transparency. Be transparent with clients. Don't promise things that you don't think you own, or don't assume things that you own as well. The clarity is really key, and the transparency. So, good principles to remember, good guardrails. So, there's already lots of questions ticking in here on different avenues. And I guess one thing I'll kick off with as well, which is always useful. So, we've said that we don't know who might own it, whether that information, the AI generated information, is owned by a client or by perhaps the person or the platform. But a nice or interesting little nuance of that might be if your staff are using AI at work, who owns what they create? Is it the employer? Is it the employee? Is it the platform? So, is there anything tips you could suggest? Because I think that's quite an interesting layer.
So, as I told you, to having copyrights, the owner will be author. So if your employee creates something, a text, a code, an image, a video, whatever, music, it will be him, the author. If the employee uses AI, it's like what I've said. It depends if he use like AI a lot, if like we have the human in the loop, a sufficient human work or not. If the employee just use AI a lot, just making prompts, we won't get any copyright protection on that. But if the employee use AI, but then or not using AI, but like then really work on that humanly, maybe he gets some copyright protection on the work. But you can, as an employer, you can put that in a contract, like in the employment contract, or if it's a contractor, you can put that in a contract that the transfer will be given to the company. But if it's not written in the contract, like the ownership of the work, if they get some copyright protection, it will be to the employee or to the contractor. So it's really important to put that in a contract with your employee contractors to receive it. For example, I have a lot of clients, for example, that they ask a graphic designer to design the logo. And they say, oh, but I paid him. So I own the logo now. But it's not because you paid contractors that you own it. You really need the written clause, the written article in the contract or the terms and conditions to really own the copyright if there is copyright on the work.
Excellent. So I thought that was a nice one to get in for people as well, because it could get lost in the personal side. Then there's almost the professional work. A question's come in from James Sophie, who has asked, would another facet or side of not being able to assert copyright be that you can't offer, perhaps substantively, AI outputs under Creative Commons or other permissive licensing? Because he said that could be relevant for public sector work that must be shared as freely as possible.
Question, thank you. So the goal of having copyrights, it's really because some of our clients say, oh, but I don't care about copyright. But it's really interesting to have copyright on some work because what you can do on that, it depends on the work, but maybe you can get some royalties from it. Maybe you can sell it to someone. Maybe you can license it to someone. So that's the question. You can license it. But if you don't have any copyright protection, it falls directly under public domain. It means that everyone can use it, everyone can copy it, and you cannot license it because you don't really own. You cannot sell a license or right that you doesn't own.
Yeah.
Yes, so it's really important to just think about it and oh, okay, maybe we should get more human in the loop to get this protection on that. Another option, if you don't get the copyright protection, maybe you can license it, but just contractually. Just it's more about the contract. It's not about copyrights. Maybe you can define with a client, with someone, okay, now we will give you the access to that, but it's more contractual, but not, we don't speak about copyright here. So for public domain, for, sorry, public offices and so on who
Yeah.
wants maybe some license, it's really important to keep the human in the loop in order to get some copyright protection.
Yeah. Excellent. Some of the other questions I think you've answered earlier, which were things like Judy had asked if she was to create a logo, should she patent it so that it is protected? So that was one of the things you mentioned earlier. Truus has asked, Sophie, in your example of the author who recorded himself modifying the AI content, you mentioned the more human work is done on the AI material, the more of the material can be hopefully copyright. Is it possible then for the modified parts of a work to be copyrighted, but the unmodified parts of the work to not be eligible? So fascinating.
That's a really good question. So in that case, the guy took something from the AI, it was like an image, and he changed so much that it was really not the same as the initial one. I have
Mm.
another case. I haven't told you about that one, but it's a really interesting one and it will answer the question. So it's also in the United States in front of the Copyright Office. And that was the other way around. So we have this woman who was drawing something, it's like roses and a face. And so she did it with a pencil. And then she put that into AI. And the AI like modernized, put some effects on the drawing. And she gets at the copyright office and she gets the protection on just the part, the drawing part, not the modern AI stuff. So for her, it's only a part of the work that is protected. So yeah, a part of it can be protected. And we have another famous case also in the United States. It's like a comic, and the girl did all the text and the placement of the text of the comic, but all the drawings, all the images was done by Midjourney. And so she got the copyright not on the whole book, not on all the comic, but only on the text disposal, but not on the images. So you can get a part of it.
Okay, so there is evidence out there of a case where that was the case. And just something's come to mind. Do you think that the reason we're seeing more cases in existence in the US or more stories and examples is because of that registration for the copyright to exist? Okay.
Exactly, because a lot of authors are going to the United States Copyright Office to register the copyright. So
Yeah.
that's why we have a lot of cases in the US. We got some now in the European Union, but it's really like maybe let's say four or five maximum, because it takes time. And in Europe or all the rest of the world, so I checked, I didn't see any case in New Zealand. But for example, it will take a long time because it's not at the moment of the registration that we will get the opinion of the judge or something. It's at the moment of the infringement because I told you we
Ah,
don't have any registration for
yep.
almost all the countries. And so it will get when we have a case, when we have someone copying you, that you will go to court because you're not happy and you will claim for copyright infringement. And because you will choose maybe, I don't know, a lawyer that doesn't know about copyright and AI, you will lose the case because he will claim about copyright and you don't get any copyright because maybe it's AI generated 100% or almost, yeah.
Wow. Yes, so fascinating. And I think that might link to David. Just a final question we'll take now, which is a short one. So he's asked if you wanted the global copyright, do you have to register in every country that, or so for the USA, for example, do you register there? Or what's your advice with that?
So as I told you, it's only in the USA that you have to register. So if you
Ah,
have a client or you have a service products and you sell a lot of things, you have really a client base in the US, I would recommend to register some copyrights in the US. But for
yes.
all the other countries, it's automatic. So you don't need a registration. You don't, please do not register online on some website. It's fraud. It's not fraud. It's fake website.
Yes.
Legally, don't need to register the copyright. So it's just automatic. If you fulfill the three conditions about being a human author or significant part of the work was done by a human, if it's original, so it's like you create from your own intuition and creative thoughts,
Expression.
and
Yeah.
if it's recorded, so it's not just an idea, because an idea cannot be protected. It has to be like in form,
Yeah.
and then it's
Something,
automatic. You're protected.
something. Excellent. Okay, wow. We have hit our time, our capacity for today, and I could keep asking. I know the chat's still going. Great comments coming in. People very thankful for your time today, Sophie, for sharing that. If you could leave people with one key takeaway, Sophie, what would that be?
After this webinar, do not stop using AI. It's a great tool. Maybe you just need to keep a real human in the loop. Just keep that in mind, and to really know what you actually own, which in most countries is less than people assume.
Yes,
Substantive human involvement plus a simple paper trail or video recording is what turns AI output from something anyone can copy because it's in the public domain into something genuinely yours. So yeah, that will be my advice.
excellent. And if people want to find out more about you or your work, Sophie, I know we're going to send some stuff after today too, but where's a quick way they can find you?
You can find me at my company, Mutatis Legal. Legal, the website is mutatis.legal. You will get the contact details. The website is both in French and English, and I'm happy to connect also on LinkedIn. I work with businesses internationally on intellectual property, AI, digital law, data protection. So thank you for inviting me to Q&A, Una. Thank you all
No,
for
not a, it's been an
attending.
absolute pleasure. And I again would echo what Sophie has said. Thank you, Sophie, first of all, for giving your time so generously and your expertise in this very gray area that people are faced with. Thanks everyone watching for giving us your time and your really valuable questions as well. We hope this has clarified what can feel like a mysterious, uncertain area or something that you've buried your head in the sand. And just as Sophie said, her final words, I'll repeat, you don't need to panic. You don't need to stop using AI. You just need to understand what you truly own. And as the saying goes, what you own owns you, sometimes as well. It's a bit philosophical for the end. So thanks again for joining us. Enjoy the rest of your day. And it was lovely spending this time with everyone.